Chapter 1. An introduction for the reader. What is legitimacy? 1.1. Two species of authority: factual, de facto, and lawful, de jure. Before we descend into the thicket of dynastic statutes, morganatic marriages, and Salic principles, a single, fundamental distinction must be drawn, a distinction of which most modern men and women, reared upon news feeds and schoolroom chronicles, are wholly unaware. It is the distinction between a power that exists and a power that possesses the right to exist. The first species of authority is factual or de facto. This is the rule of force, the pistol at the temple, mastery of the army, the constabulary, the television apparatus, the machinery of taxation. It is the authority that declares, "I am here because I am able to be here." Within a prison, the strongest inmate wields de facto power over his fellows, though juridically he is nothing more than a number. In a dictatorship, the general whose tank divisions are loyal to him wields de facto power, even if his country bears the juridical designation of a republic. In an occupied land, the commander of an enemy patrol wields de facto power over the civilian populace, though no law vests him with such a right. The second species of authority is lawful, or de jure. This is authority grounded in law, tradition, compact, and continuity. It is the authority that declares, "I am here because it has been so ordained by rule, and those rules are acknowledged by the people over whom I govern." A judge possesses de jure authority because his appointment conforms to the Constitution. A president elected in accordance with the law possesses de jure authority. A monarch who has inherited the throne in unbroken conformity with indisputable dynastic statutes possesses de jure authority. In an ideal order, these two species of authority would coincide. He who possesses the lawful right to govern would also command the force requisite to exercise that right. He who commands the force would stand supported by the law. But the world is not an ideal order, and the history of mankind is, to a very considerable degree, the history of the divergence between the de facto and the de jure. Most men confuse these two notions. They behold a person seated upon a throne, arrayed in a crown, his portraits hung in state offices, his cipher borne upon the epaulets of the constabulary, and they infer, since he must possess the right. This is a logical fallacy. It is a substitution of appearances for substance. Let us take a simple illustration. Were I to seize your house with the aid of an armed band, post sentries at the gates, and proceed to pass myself off as the proprietor, the neighbors might come to believe that I am the lawful master. The constabulary might refrain from intervention out of fear. The local authorities might even recognize my rights in order to avert a conflict. That is de facto power. Yet it does not make me the lawful proprietor. Your title deeds constitute the de jure right. And sooner or later, if you possess sufficient courage and resolve, you may yet restore your rights. The matter stands in precisely the same fashion with monarchies. We behold kings and queens at ceremonies. We behold their signatures upon statutes. We behold armies swearing fealty to them. And we grow habituated to the thought, they endure, therefore it is meet that they should endure. But this book is a study of the chasm between existence and right. In the chapters that follow, we shall demonstrate that not a single one of the presently subsisting European monarchies possesses lawful, de jure legitimacy. Every one of them is the product of usurpation, parliamentary stratagem, foreign intervention, dynastic rupture, and juridical fiction. They subsist because they command the constabulary, the soldiery, and the engines of propaganda. Yet they possess no right to subsist. This book is not an academic divertisement. It is an endeavor to restore the understanding that authority must be founded upon law and not upon force. And if, after this chapter, the reader retains but a single distinction, that between de facto and de jure, he shall already be armed with a knowledge that the greater portion of his fellow citizens lack. 1.2. What rendered a monarch legitimate in classical European law? Now that we have established the distinction between factual authority and lawful authority, we must pose the question that follows directly. What, precisely, rendered a monarch lawful in the classical epoch of European history? What criteria had to be satisfied so that no one, neither bishop nor duke nor neighboring sovereign, could impugn a man's right to the throne? The answer lies within a millennium of European juridical tradition, a tradition that was savagely ruptured by the French Revolution and thereafter shattered beyond repair by the two world wars. The modern observer, gazing upon King Charles III or King Willem Alexander, does not apprehend what a pitiable caricature of legitimacy their pretensions represent. To apprehend this, one must first look backward. Classical European legitimacy rested upon four pillars, for buttresses which seldom existed in absolute perfection, yet the absence of any single one of them opened a fissure through which civil war, dynastic crisis, or foreign intervention could seep. The first pillar, blood. A monarch had to be born a monarch, not to become one, not to be appointed, not to be elected. Born. The blood coursing in his veins had to be the self-same blood that had coursed in the veins of his forebears, who had governed that land across the generations. This is no poetic metaphor. It was a juridical principle. In the medieval chronicles and legal instruments, we encounter repeatedly the phrase natus est ad regnum, born unto kingship. This did not signify that the monarch was from birth superior to other men. It signified that the right to the throne was transmitted exclusively through blood. Any departure from this principle was regarded as usurpation. If a king died without an heir, the kingdom was plunged into crisis. Sometimes this crisis resolved itself through civil war, as in England between York and Lancaster. Sometimes through the invitation extended to a foreign prince who could demonstrate at least some drop of the requisite blood, as occurred in a number of realms, of which we shall speak further. Yet in both instances, all the parties concerned understood one thing: blood was the sole foundation. The second pillar, descent. The blood had to be not merely royal. It had to be untainted. This signified that both parents of the monarch, in certain traditions, all four grandparents, had to belong to royal, or at the very least to the highest noble, houses. A marriage contracted with a person of non-royal blood was termed morganatic, from the German Morganie, mourning gift, because all that such a wife received was a personal gift from her husband, not a title, and not the right of succession for her children. Issue born of a morganatic union were regarded as incapable of inheriting the throne. This rule was virtually universal across Europe. Exceptions were admitted with extreme rarity and invariably provoked scandal. Modern readers who behold upon the Swedish or Norwegian throne persons whose mothers were common shop assistants or escorts from the modeling profession have not the faintest conception how profoundly such a circumstance affronts a centuries-old legal tradition. The third pillar, indigenat, a Latin term, which may be rendered as native origin or belonging to the soil. A monarch had to be not merely a person possessed of royal blood. He had to be a native of his own kingdom, born upon its territory, speaking its tongue, belonging to its culture. This principle, today wholly ignored. The Windsors are Germans, the House of Orange are Germans, the Glucksbergs are Germans, was a cornerstone of European dynastic law. It shielded kingdoms against foreign influence. Had anyone in the 17th century proposed to place a German prince upon the French throne, war would have ensued. Had anyone proposed to place an Austrian archduke upon the Spanish throne, this came to pass only after Spain had been laid waste by the War of the Spanish Succession, and it was received as a national humiliation. Today we witness a complete disregard of this principle. Yet that does not mean the principle has ceased to exist. It means that those who occupy the thrones prefer not to recall it. The fourth pillar, dynastic continuity. Legitimacy is not transmitted across a vacuum. If the dynasty is interrupted, if the last king lacks lawful heirs, then the crown cannot simply be transferred by a parliament to another house. The crown either reverts to its origins, to the elder branch of the dynasty, which may have been bypassed at an earlier date, or the kingdom becomes a republic, or there supervenes an interregnum which can be resolved only through the universal recognition of a new dynasty, a recognition ordinarily sealed in blood upon the battlefield. No parliament in Europe ever possessed the right to appoint a new sovereign. Parliaments are the creatures of monarchs. They exist for counsel and for the granting of taxes, not for the disposition of the crown. When a parliament enacts a statute of succession, as in England in 1701, as in Denmark in 1853, as in the Netherlands in 1815, it commits an act of usurpation. It arrogates unto itself a right that never belonged to it. A monarch who receives his throne from a parliament becomes, not a monarch, but the servant of that parliament. These four pillars, blood, descent, indigenate, and dynastic continuity, constitute the skeleton of classical European legitimacy. In the passages that follow, we shall examine each in greater detail and thereafter apply them to the present-day monarchies of Europe. The outcome of this application, as we already know from the preface, will be devastating. But before one strikes a blow, one must first properly whet the blade. 1.3. Whence arose the laws of succession, the Salic law, canon law, and dynastic compacts. The reader acquainted with the modern political apparatus may pose a perfectly lawful question. Whence, in the first place, did these laws which we denominate dynastic law arise? Who wrote them? Who ratified them? Where sits the parliament that enacted them? Where is the volume containing the schedule of these statutes, the sort of volume a man might purchase in a bookshop? Such questions betray a fundamental misapprehension of the nature of dynastic law. It was not fashioned behind a writing desk by jurists. It was not adopted by ballot. It grew forth from the soil, from blood, from the sword, from the altar. It is customary law, consuetudo, accumulated across centuries, fortified by precedent, and hallowed by the Church. And to comprehend this law, we must undertake a journey across a millennium of European history. The Salic Law, Lex Salica. We begin with the most celebrated and the most grievously misrepresented source of dynastic law. The Salic Law was reduced to writing about the year 500 of our era at the command of Clovis, king of the Salian Franks. It was no statute of succession. It was a compilation of the customs of a single Germanic tribe, a record of how inheritance was to be partitioned, how thieves were to be punished, how disputes were to be resolved. Yet among these customs there was one paragraph which, 1,000 years later, overturned Europe. It concerned the inheritance of land, and it declared, in one of its later redactions, that land does not pass through the female line. De terra vero salica in mulierum nulla portio hereditatis transit. As touching Salic land, no portion of the inheritance shall pass to a woman. What must be grasped is this: the Salic Law was never enacted by a French parliament. No parliament then existed. It was interpreted by jurists as a living principle, and that interpretation received recognition because it was advantageous to the French nobility, who had no desire to behold an English king upon the throne. From that time forward, the Salic Law became the very emblem of dynastic law. It was adopted, rejected, modified, circumvented, but never wholly disregarded. Even today, when not a single European monarchy adheres to it, the mere fact of its existence serves as a reminder. Dynastic law subsists, it is ancient, and it cannot simply be abrogated by a parliamentary act. Canon law. The second fountainhead of dynastic legitimacy is the law of the Church. Throughout the greater part of European history, a monarch was anointed unto kingship. This was no mere ceremonial. It was a sacramental act. A bishop, or the Pope himself, laid hands upon the head of the future sovereign, anointed him with holy oil, and from that moment the monarch became the Lord's anointed. The Catholic Church, unlike any parliament, possessed a universal jurisdiction. Her laws, the canons, ran from Ireland unto Poland, from Sicily unto Sweden. And these laws governed marriage, and marriage was the very foundation of inheritance. Canon law prescribed that marriage could be contracted only between two free persons, that close consanguinity barred matrimony, that divorce was impossible, dissolution of the bond being admissible only in the most narrowly circumscribed cases. A violation of these rules rendered a marriage null, ab initio, from its inception. An issue born of a null marriage were accounted illegitimate, bastards, incapable of inheriting. Herein lay vast opportunities for dynastic manipulation. A king might wed a person of non-royal blood, and the Church might recognize the union as valid, provided it had been contracted with papal dispensation. Or she might declare it retroactively void, should the political situation shift. It suffices to recall the history of Henry VIII and his 6 wives, and the consequences that flowed from his desire to annul his marriage to Catherine of Aragon. Ecclesiastical control over matrimony signified that no monarch could simply take unto himself a wife of his mere choosing. He was obliged to obtain consent from the Pope, from his own clergy, from his kindred. And this consent was no formality. It was a complex juridical procedure, consuming months and, on occasion, years. Today, when we witness the heirs to European thrones marrying common mortals, we must understand this. It is a most grievous violation of canon law. The Church could declare these unions null, had she the will. But the Catholic Church today does not wield the authority she commanded 500 years ago. The Protestant churches are yet more pliant. Yet the bare fact that these marriages are recognized does not render them legitimate according to the canons of classical law. Dynastic compacts and family pacts. The third source of dynastic law is the agreements entered into within the dynasty itself. The royal houses of Europe were not merely families. They were corporations, possessed of vast assets, lands, cities, titles, rights to the raising of taxes. And, like any corporation, they had their own statutes. These statutes were termed family pacts, Hochgesetze in the German tradition. They determined who might inherit, who might contract marriage, and what was to be done should the dynasty suffer interruption. They were not laws of the state. They were private agreements among the members of the family. Yet they possessed binding force, because behind them stood an army and an immemorial tradition. The most renowned of these pacts is the Pragmatic Sanction of 1713, promulgated by the Emperor Charles VI. It ordained that the Habsburg dominions might pass through the female line, should the emperor lack sons. It was an act of desperation, an attempt to rescue the dynasty from extinction. From the standpoint of dynastic law, it was a most grievous violation. Charles VI possessed no right to alter the fundamental laws of succession at his mere pleasure, and the price of this violation was paid forthwith. Upon his death there erupted the War of the Austrian Succession, 1740 to 1748, in which hundreds of thousands perished. His daughter, Maria Theresa, was able to retain the throne only by force of arms, but that was de facto power, not de jure right. The Pragmatic Sanction stands as an illustration that even a mighty emperor cannot by simple edict alter dynastic law. Should he attempt it, war, bloodshed, and chaos follow. And this lesson ought to be borne in mind by everyone who today defends absolute primogeniture in the European monarchies. The sole difference is that in the 18th century, men paid for the violation with the lives of soldiers. In the 21st century, they simply acquiesce in silence to the forgery. Another example is the Nassau Family Pact of 1783, which to this day regulates succession in Luxembourg and the Netherlands, in a modified form. This is a document drawn up by a body of aristocrats for their own governance. It was not approved by the people. It was not ratified by any parliament. It is simply a paper subscribed by a handful of men several centuries ago, yet it still determines who shall wear the crown. What does this signify for the modern reader? It signifies that dynastic law is family law, not state law. It does not submit to democratic procedures. It subsists within its own universe, governed by its own rules. And when a parliament enacts a law of succession, it trespasses upon alien ground. It endeavors to regulate that which it possesses no right to regulate. The reader may ask, if an emperor issued a decree, is that not law? Did he not possess the right? The answer is no. Dynastic law is not positive law, which may be altered at will. It is customary law, which subsists independently of the sovereign's volition. Charles VI could issue the Pragmatic Sanction, but he could not compel Europe to recognize it. And Europe did not recognize it. Bavaria, Prussia, Saxony, France, all of them contested Maria Theresa's succession because they held the Salic law to have been violated. And only after 8 years of war, which exhausted all parties, was a peace concluded that confirmed her rights, but upon terms that cost Austria the province of Silesia. The Pragmatic Sanction is not proof that a monarch can alter dynastic law. It is proof that he cannot. The synthesis, how these sources functioned in concert. In practice, classical European dynastic law constituted a composite of all three elements. The Salic law, or its absence, determined whether women might inherit. Canon law determined which marriages were valid. Family pacts determined the particulars of succession within the dynasty. Should a conflict arise, for example, canon law deem a marriage null, whilst a family pact recognized the issue of that marriage as heirs, war ensued. Literally, dozens of European wars of the 17th and 18th centuries were wars of succession: the Spanish, the Austrian, the Polish, the Bavarian. Men perished in their millions so that the correct sovereign might occupy this throne or that. Gazing upon these wars from the elevation of our own age, we may deem them senseless. Yet the very fact that men were prepared to die for these principles speaks to their gravity. Dynastic law was no abstraction. It was the foundation of order. Breach it, and the edifice of the world crumbles. The edifice has not crumbled in our own day because the monarchies have forfeited real power. They have become stage scenery. Yet the rules by which this scenery subsists remain in force, or, at the very least, ought to remain in force. And when we discover that these rules are being grossly violated, we possess the right to ask, what, in truth, remains of monarchy, if its foundation is a juridical fiction? 1.4. The criteria of legitimacy, blood, descent, indigenate, dynastic continuity. Now that we have examined the historical sources of dynastic law, we may return to the four pillars set forth in section 1.2 and consider them in greater detail. For it is precisely these criteria, blood, descent, indigenate, and continuity, that shall serve as our measure in the appraisal of every presently subsisting European monarchy. Blood. Blood is at once the simplest and the most vexing criterion. Simple, because it reduces to a single question: is the person in question the direct descendant, in the male line, of the founder of the dynasty? Vexing, because in practice that line is frequently interrupted, and jurists are compelled to rack their brains over which collateral male kinsman possesses the nearest right. In a system grounded upon the Salic law, a woman cannot under any circumstances inherit the throne. Even if the king lacks sons, even if all his brothers are dead, the crown passes to the next male kinsman in the collateral line, an uncle, a cousin, a nephew, but never to a daughter. A woman cannot be a monarch. A woman cannot transmit the right to the throne to her children. A woman is a dead branch upon the dynastic tree. This is precisely the manner in which France functioned across the centuries. When the last direct Capetian died in 1328, the crown passed not to his daughter or to his sister, but to his cousin Philippe de Valois. And this ruling, grounded in the Salic law, was contested by no one within France, though the English, who adhered to a different system, essayed to employ the female line to substantiate their own pretensions, thereby unleashing the 100 Years' War. Today, surveying the European monarchies, we behold a wholesale contempt for this principle. In Sweden, the Netherlands, Belgium, Denmark, Norway, women not only inherit, but enjoy precedence over younger brothers. This is no modernization. This is a rupture with a 1,000-year-old tradition. And those who defend equal primogeniture must candidly confess they repudiate the Salic law, which constituted the cornerstone of European monarchical legitimacy throughout the greater portion of its history. Descent. Descent is the criterion that the modern monarchies flout in the most brazen fashion. In classical law, a monarch had to spring from royal blood, that is to say, both his parents had to be either sovereigns or the children of sovereigns. A marriage contracted with a person of non-royal station, a morganatic marriage, deprived the issue of all rights to the throne. Today we witness the heirs to thrones wedding mere commoners. King Willem-Alexander of the Netherlands married Maxima Zorreguieta, whose father was a minister in the Argentine government, not of royal blood. King Philippe of the Belgians married Mathilde Biedicum d'Ancause. She springs of noble, but not royal, stock. Crown Prince Haakon of Norway married Mette Marit Jessam Højby, a former waitress and single mother. Crown Princess Victoria of Sweden married Daniel Westling, her personal trainer and the proprietor of a gymnasium. From the standpoint of classical dynastic law, every one of these marriages is morganatic. Every child born of these unions is illegitimate in the sense of the law of succession, and every one of the present heirs to the European thrones is a usurper, for they occupy thrones to which they possess no right. Indigenate. Indigenate is, perhaps, the most scandalous of the criteria, for its violation is the most glaringly apparent. A king must be a native of his own country. He must have been born upon its soil. He must speak its tongue as his mother's speech. Indigenate, however, signifies something far deeper than the mere place of birth. It signifies origin. A king must not simply be born upon the territory. He must spring from a dynasty that has been bound to that soil for centuries. A German prince born in Holland remains a German by blood. His children, his grandchildren, his great-grandchildren, likewise. A single alteration of the place of birth does not efface a millennium of blood ties to another land. And it must be noted with all due emphasis, dynastic law knows no statute of limitations. Blood is not bleached clean by the passage of generations. If the founder of a dynasty was a foreigner, his descendants remain foreigners by blood for all time. The principle of indigenate demands that a king descend from a dynasty that governed that land for centuries, not that he be the scion of an invited foreign prince. The Belgian monarchy was fabricated in the year 1831. It is not yet 2 centuries old. This is no ancient dynasty. It is an artificial construct, fashioned ex nihilo by the great powers out of German raw material. Let us survey the present European sovereigns. Charles III, King of the United Kingdom, was born at Buckingham Palace in London. This would appear to satisfy the criterion. Yet his dynasty, Saxe-Coburg-Gotha, rechristened Windsor in 1917, is of German origin. His forebears were dukes in Germany. They came to England solely because Parliament invited them in 1714, after the Protestant line of the Stuarts had run its course. Willem-Alexander, King of the Netherlands, was born at Utrecht. Formally, this satisfies the requirement of birth upon the territory. Yet the principle of indigenat demands not only birth, but descent from a native dynasty. The House of Orange-Nassau is of German origin. Its ancestors were counts in Nassau, in modern Germany, and it was the wars of the 16th century that brought them into Holland. Willem-Alexander is the descendant of German interlopers, not of native Dutch rulers. From the standpoint of classical dynastic law, this alone suffices to establish a violation of indigenat. Philippe, King of the Belgians, was born at Brussels, conforming to the requirement. Yet his dynasty, Saxe-Coburg-Gotha, the self-same as the British, is of German origin. The first king of the Belgians, Leopold I, was a German prince invited to the throne after the attainment of independence in 1831. Need one add that no Belgian blood flows in the veins of this dynasty, nor ever could, since the Belgian state itself came into being only in 1830? Frederick X, King of Denmark, was born at Copenhagen, conforming. Yet his dynasty, the House of Glucksburg, is of German origin. The first king of this line, Christian IX, was a German duke whom the Danish parliament elected to the throne in 1853 upon the extinction of the main line of Oldenburg. Harald V, King of Norway, was born at Oslo, conforming. Yet his dynasty is likewise Glucksburg, a Danish branch of a German house. And the first king of modern Norway, Håkon VII, was a Danish prince whom the Norwegian parliament invited to the throne after the dissolution of the union with Sweden in 1905. Karl XVI Gustav, King of Sweden, was born at Haga Palace in Sweden, conforming. Yet his dynasty, the House of Bernadotte, is of French origin. The founder of the dynasty, Jean-Baptiste Bernadotte, was a marshal of Napoleon, whom the Swedish parliament elected as heir to the throne in 1810. A pattern emerges with unmistakable clarity. Every one of the present European monarchies is governed by a dynasty of foreign extraction. Not a single one of them can trace an unbroken, immemorial bond to the native dynasties of their respective lands. This is a fundamental violation of the principle of indigenat. Dynastic continuity. The fourth criterion is continuity. A monarchy must be transmitted from father to son without interruption. Any breach, the death of a king without an heir, an abdication, a deposition, creates a juridical problem of the first magnitude. The history of the European monarchies is replete with such breaches. The wars of succession were fought precisely because a breach created a vacuum of authority. And in the majority of cases, that vacuum was filled by a new dynasty which proved its rights by the sword. Yet in modern Europe, we witness something altogether different. Breaches are settled by parliamentary acts. In 1701, the English Parliament enacted the Act of Settlement, which transferred the crown to the House of Hanover because Queen and had no surviving issue. In 1853, the Danish Parliament enacted a law transferring the crown to Christian of Glucksburg. In 1905, the Norwegian Parliament elected a king. In 1975, the Spanish Cortes, a parliament still Francoist at the time, proclaimed Juan Carlos king. Parliament possesses no right to dispose of the crown. This is an axiom of dynastic law. When a parliament arrogates this right unto itself, it commits an act of usurpation. And a monarch who receives the crown from the hands of a parliament becomes, not a sovereign, but the servant of that parliament. Thus, all the present European monarchies are not monarchies in the classical sense. They are republics arrayed in a crown, polities in which the parliament is the true sovereign, and the king is its hired functionary. Yet they preserve the outward trappings of monarchy, titles, crowns, palaces, ceremonials, in order to conceal this fundamental substitution. 1.5. Why a constitution cannot render a monarch legitimate. At this juncture, the reader may object, but all these countries possess constitutions wherein it is written that the monarchy is the form of government. Does this not render it legitimate? The question appears reasonable, for we have grown accustomed to thinking of a constitution as the supreme law. We live in an age of constitutions. We believe that if a thing is inscribed in a constitution, it is thereby rendered legitimate. Yet this belief is a product of the 19th and 20th centuries, and it is erroneous. A constitution is a document written by men, ordinarily, by a company of jurists and politicians assembled in some building after a war or a revolution. They compose a text, That text is thereafter ratified by a parliament or by a referendum, and from that moment it becomes the fundamental law. But who vested these men with the right to write a constitution? Who vested the parliament with the right to ratify it? Who vested the people with the right to vote upon it? The answer is no one. They arrogated this right unto themselves. This is what is termed constituent power, a power grounded upon nothing other than its own resolve. There is nothing objectionable in this per se. Constitutions are necessary, and they discharge a vital function. Yet it is essential to grasp this. A constitution is no sacred text lowered from the heavens. It is a political document, reflecting the balance of forces prevailing at the moment of its drafting. Parliament cannot dispose of the crown. In the classical European tradition, the crown stood above Parliament. Parliament, wheresoever it existed, was a consultative body attending the sovereign. It did not create the sovereign. It could not alter the rules of succession. It could not transfer the crown to another dynasty. When the English Parliament enacted the Act of Settlement in 1701, it committed a revolutionary act. It arrogated unto itself a right that had never belonged to any parliament. And it did so because it possessed the force, the army, the support of the nobility, the command of the purse. Yet force is not right. Force is de facto, not de jure. Since that time, European parliaments have repeated this act again and again. The Danish Parliament in 1853, the Norwegian Storting in 1905, the Spanish Cortes in 1975, the States General of the Netherlands in 1815. On every occasion, they declared, "We, the representatives of the people, proclaim such and such a person king." But this is a logical fallacy. A parliament cannot proclaim a king, because a king must be king by right of birth, not by decision of a majority. If a majority can proclaim a king, then a majority can also depose him. And then it is no longer a monarchy, but an elective office. The constitutional monarch is an oxymoron. The very notion of a constitutional monarchy is internally contradictory. If a monarch is bound by a constitution, if he cannot act without the consent of parliament, if his power is circumscribed, then he is no monarch. He is a president bearing a hereditary title. In the classical understanding, a monarch is a sovereign. He submits to no one save God alone. His word is law. He may issue statutes, declare war, conclude peace, appoint ministers. He does not seek permission from Parliament. Parliament may counsel, but it may not command. Constitutional monarchs do not answer to this definition. They cannot issue statutes. They cannot declare war. They cannot even select the color of their neckties if the choice threatens to spark a political scandal. They are stage scenery, symbols, marionettes. But if they are mere stage scenery, to what end are they maintained? Why disburse billions upon the upkeep of palaces, royal yachts, private aeroplanes, and fiscal immunities for families that wield no real power? Why preserve an institution that discharges no useful function? The answer is simple: to legitimate the real power. The parliament and the government employ the monarch as a screen. They declare, the king has signed the law, although the king possesses no right of refusal. They declare, the king has appointed the prime minister, although the king has no liberty of choice. They invoke an ancient title and ancient ceremonials to lend the semblance of legitimacy to their own decisions. But this is a deception, and this deception stands exposed the moment we apply the criteria of classical dynastic law. Not a single one of the present European monarchs satisfies these criteria. Not by blood, not by descent, not by indigenate, not by dynastic continuity. They are usurpers, seated upon thrones that do not lawfully belong to them. What remains for the reader? If the reader has persevered to this point, he may feel a certain vertigo. Too many laws, too many exceptions, too much history. And this is perfectly natural. Dynastic law is an intricate matter. It was never intended for mass consumption. It was forged across centuries for a narrow circle of initiates. Yet this does not mean it lies beyond comprehension. The essential lesson to be drawn from this chapter is simple. 1. Legitimacy is of two species: de facto, force, and de jure, right. Most men confound the two. 2. Classical monarchical legitimacy rested upon four criteria: blood, descent, indigenate, and continuity. 3. The sources of dynastic law are customary law, the Salic law, canon law, and family compacts. Parliaments do not number among them. 4. A constitution cannot render a monarch legitimate, because Parliament possesses no right to dispose of the crown. In the chapters that follow, we shall apply these criteria to each European monarchy in turn. The result: as the reader may already divine, will be devastating. But the reader is now armed with knowledge. He will be able to judge for himself how far the pretensions of those who style themselves the kings and queens of Europe rest upon lawful ground. And now, onward to the unmasking.